It is now day 8 since I contacted Norfolk County District Attorney Michael Morrissey to see whether he would confirm or deny reports in Vanity Fair magazine that all of his top prosecutors refused to retry the Karen Read case. I guess he's been busy.
Norfolk County District Attorney Michael Morrissey may have been busy on his burner phone. I'm Lainey Law.
And I'm Attorney Andrew Myers.
Andrew, what is this that we're hearing about him having some type of burner phone?
Well, a couple of weeks ago, we read over Mark Bederoff's letter regarding Aiden Kearney. I've been corrected with the pronunciation, thank you. And we read the letter by Mark Bederoff, his attorney, who pointed out that the prosecution is in the Turtle Boy case is still saying, well, we, at least at that time, we still don't have the phone downloaded. But in fact, when they confiscated Mr. Kearney's telephone, they almost immediately, over a year ago, on October 31st of 2023, at that time, conducted the downloading of all of the material on that phone. And they also found out that Norfolk County District Attorney Michael Morrissey allegedly was using a burner phone to contact witnesses and to contact the court. And so now, this week, some new motions were filed. In fact, the day that we are doing this episode, a flurry of motions have been filed by the defense in the case. One of the more significant ones in my mind is this one, Defendant Karen Read's motion for discovery of communications in the possession, custody, and control of the Commonwealth. So this involves the burner phone. Now comes the defendant, Karen Read, and respectfully moves this honorable court, pursuant to Mass Rule of Criminal Procedure 14, to order the Commonwealth to produce all communications made by the District Attorney Michael W. Morrissey. As grounds for this motion, recent reporting corroborated by documentary evidence demonstrates that D.A. Morrissey used his personal email address to communicate ex parte with Stoughton District Court personnel and judges. In the publicly available email sent by D.A. Morrissey to Justice Stacey Fortes, copying Massachusetts Trial Court Administrator Thomas Ambrosino, Justice Daniel O'Malley, who presided over Ms. Read's case while it was pending in the district court, Philip McHugh, Deputy Court Administrator, and First Assistant District Attorney Lynn Balland, who I understand is now retired, Ms. Balland or First Assistant Balland. D.A. Morrissey attached what appears to be a text message or iMessage sent to a member of the prosecution by a witness in this matter that constitutes a discoverable statement pursuant to Mass Rule of Criminal Procedure 14. This email and presumably a number of other communications that are material and relevant to Ms. Read's case or constitute statements of witnesses are in the possession, custody, and control of the Commonwealth, insofar as D.A. Morrissey is the District Attorney of Norfolk County. Ms. Balland is or was his first assistant, and both are members of the Commonwealth for the purposes of Rule 14. Well, of course they are. That's the District Attorney, and their pay comes out of the Commonwealth. Accordingly, Ms. Read respectfully moves this honorable court to order the Commonwealth to produce any and all communications by D.A. Morrissey that are discoverable under Rule 14, as well as any and all ex parte communications with the court and or judicial staff regarding this case. An affidavit of counsel is attached hereto and is incorporated herein by reference. What that's all about is a motion is a document that's filed in court, asks the court to literally move and do something, but you can't in Massachusetts file a motion unless it's supported by an affidavit of facts. This is interesting because it says that, and there are allegations, but it says that District Attorney Morrissey was communicating with not only a witness, but also the courts. That's an ex parte communication. That's no different than if I picked up my phone right now and called a judge in one of my cases that's pending. I mean, that's a strict no-no. So to put this in context, as a practicing attorney, you don't call a judge. The only time you address a judge formally is in court when the stenographer is there and the opposing counsel is there. But the same is true of a prosecutor. A prosecutor is nothing more than a party in the case. You're the prosecutor, and then there's the defense on the other side. You don't talk to the judge unless it's an open court. The stenographer, the court reporter is there. The other side is there. Then, yeah, you say whatever you want to the judge. If you're smart, you say smart things. But lest I digress, on October 17th, 2024, attorney Mark A. Betterow filed a letter with this court directed to Norfolk County Special Assistant District Attorney and former Judge Robert Cosgrove. In his letter, Mr. Betterow detailed communications between Ms. Jennifer McCabe, remember her, and a yet unknown member of law enforcement, revealing that DA Morrissey had communicated on an ex parte basis with members of the Massachusetts Trial Court and Stoughton District Court, including Honorable O'Malley J. presiding. So if that's true, I mean, now the question is whether the court is actually going to allow this and order Mr. Morrissey to turn over his cell phone.
I don't think that. What do you think? I don't think that they're going to do that. I don't know. I feel like they would be more in his favor.
I kind of think they have to, because the background of this is ever since they decided that they're going to ratchet things up in trial 2.0 of Karen Read, the prosecutor, Hank Brennan, has now filed a whole bunch of his own motions. He's seeking the cell phone of Karen Read's father. He wants the father's cell phone. He's named a bunch of different experts, including a video expert, including a new telemetrics expert. Did I say that right? A new expert to go in and take a look at the interior of the car. So in response to the new special prosecutors ratcheting things up, the defense is doing the same. They filed a whole bunch of different motions on the same day as this one, motions to question the way Mr. Brennan is doing the telemetrics and saying that their expert kind of screwed up. They want transcripts from sidebars that were held in Karen Read's trial, because those were all ordered to be impounded. And now defense attorneys Yannetti and Jackson are saying, hey, if we face these same issues or a ratcheted up special prosecutor, we have every right to go back and take a look at what was done in sidebar. You can't remember a 2.5 month long trial, everything that was said in every sidebar. That would be ridiculous.
There's a reason it's in the sidebar. Also, it's like you're putting it to the side for a moment. It's like not even like the major point of it. Yeah.
And another crazy thing that Hank Brennan, the special prosecutor, is doing now is he has issued a subpoena for the actual interview tapes of Boston Magazine's interviews with Karen Read. I don't know if you remember, but back in the fall of 2023, when things were really heating up in the Karen Read case, Boston Magazine published an 18-page article that was really good. It was a good entry point into the case because it went into a lot of the background, and the whole tenor of the article was this has split the entire town. There's the pro-Karen Read people, the anti-Karen Read people. There's Turtle Boy. There's a lot of different elements. But in doing that article, the reporter did some taped interviews with Karen Read. And now Mr. Brennan, the special prosecutor, has issued a subpoena for those. And so by ratcheting things up on that side, now the defense has decided to do the same, but as well they should, where there are allegations that Mr. Morrissey used a burner phone to contact witnesses and judges.
And that's a serious accusation, too, to be doing that. I mean, like you said, it's inappropriate. I also, like, if it's true, I feel like that has some level of intent behind it as well, to be using specifically like any separate, like if you're communicating them on, like, whether it be a personal email or a separate personal device, I think that's an active choice that they're making.
Well, they caught the prosecution lying outright in the Carney case, where they said, oh, well, we don't have the contents of his phone yet. We don't have them yet, now a year after it was seized. And yet they found them communicating the substance of what was on his phone. So You say, was it a lie or was it a mistruth? Or was it just, as the pleadings say, patently false? Pick your words. In his email, which Mr. Morrissey sent from his personal email address while copying First Assistant Bill Ann's official Massachusetts government email address, DA Morrissey detailed the fact that Mr. Chris Albert, another witness in this matter, had sought an ex parte harassment prevention order against Aidan Carney, which was denied by Justice O'Malley. Despite the fact that these hearings are public, DA Morrissey accused a member of the Stoughton District Court staff of leaking information about the harassment prevention order proceedings to Mr. Carney. DA Morrissey alleged that Mr. Albert's affidavit in support of his harassment prevention order was improperly disseminated to a third party. DA Morrissey appended a text message or iMessage. What's the difference between a text message and an iMessage?
So I think with the specification of iMessage would be that iPhone has like their own proprietary messaging system where text messages traditionally, I forget, it's like RCMS, and I'm going to get clocked on that. I don't know if that's necessarily it, but it's something along those lines where they're just kind of two different messaging formats. So while you're thinking it's just text from an iPhone, it has like its own proprietary thing that I think is now going away. So now it's going to be the same format as like, as people say, like the green bubbles.
So I guess like, the little green bubbles, like Brian Higgins, I think you're hot. Do you really? Remember those from the trial and the little green bubbles?
Exactly, yeah.
So in other words, it's a difference without a distinction.
Yeah.
DA Morrissey appended a text message to his email from Mrs. McCabe, Jen McCabe, which reads, I know it's late, but I am horrified that Chris Albert didn't get it, and I am even more disgusted that for the second time, someone from the court leaked it right away to Mr. Carney. DA Morrissey directly referenced this matter, which he referred to as the Commonwealth versus Reed M case in his email. He further notes in his email that the Commonwealth was informed by Mr. Albert and others that Mr. Carney had been provided with the harassment prevention order affidavit filed by Mr. Albert, indicating that a number of witnesses in this matter had contacted either the Norfolk County DA's office, the Massachusetts State Police, or another police department involved in this case. Regardless, the Commonwealth has, via DA Morrissey, acknowledged that it is in receipt of statements from a number of witnesses in this matter, which were apparently withheld from the defense. So that they have witness statements is not a big deal, but under the rules, their obligation is to disclose them and provide them through discovery, and they didn't do that. So without citing any specific statute, rule, or regulation, DA Morrissey opined that the receipt of an affidavit in support of a harassment prevention order by a defendant in that very harassment prevention order proceeding was completely unacceptable and must be resolved immediately. Well, all right. The legal standard, I think I just said, is that if they have that kind of exculpatory material, they have a duty to disclose it. So we'll skip over that and get to the next part that I think is really very, very, very important. And that is, some people sitting at home who have some basic legal knowledge will say, well, wait a minute, isn't that attorney work product? Isn't that confidential communication? Isn't that something that he would never have to turn over? It's a case of a little bit of knowledge is dangerous, because the answer is no. It is axiomatic that a district attorney himself is a member of the Commonwealth or the prosecution for the purpose of a discovery analysis. The use of a personal cell phone or email address does not shield otherwise discoverable information from production, noting that text messages sent or received by state employees on personal cell phones that pertain to official business are public records. And I skipped over the fact that all of those statements are supported by citation to law.
So I have a question.
Yeah.
Does this mean that you don't cut up the SIM card and dump it in a military fire?
No, especially the day after you get a non-dissemination. No, I would advise against that. I would advise you not to do
Just
that.
wanted to check. Just in case he gets any ideas.
People are playing fast and furious with phones and SIM cards in this case. Mass R Crim P 14 provides that the defendant may move, and following its filing of the certificates of compliance, the Commonwealth may move for discovery of other material and relevant evidence not required by the automatic discovery rules. So what I was saying before is, can't they hide behind the work product rule? This is my attorney work product. In other words, if we're in the middle of litigation and the other side, says, Mr. Myers, we want to see your notes. No, you can't see those because that is my work product. But the reason Mr. Morrissey can't hide behind that rule is this. The work product rule exempts from discovery those portions of records, reports, correspondence, memoranda, or internal documents which are only the legal research, opinions, theories, or conclusions of the adverse party or his attorney and legal staff. Rule 14 preserves the core of the work product doctrine by sheltering the mental processes of the attorney. In other words, if I'm in the middle of litigation, the other side can't ask for my scribbly notes. Not that they could read them anyhow, but they can't ask for them because that's my mental processes, or the lack thereof, as the case may be, in the middle of a trial. The doctrine encompasses prosecutors' notes made in preparation for trial, including notes from interviews with witnesses, quoting a seminal Supreme Court case, Hickman. Proper preparation of a case demands that prosecutors assemble information, sift what they consider to be relevant from the irrelevant facts, prepare their legal theories, and plan their strategies. So all of that is protected. However, there is no indication that anything in the publicly available email sent by D.A. Morrissey from his personal burner email address could reasonably be construed as constituting work product under Mass Rule of Criminal Procedure 14. On the other hand, D.A. Morrissey's email includes a message from Ms. McCabe that would constitute a statement under Mass Rule of Criminal Procedure 14, and which should be disclosed to the defense. As noted in the reporter's notes to the rule, prior informal statements not intended for court are not only often admissible at trial, but often more probative than formal signed statements in anticipation of litigation. On this view, if the police have taken a statement of a witness who will testify, it should be discoverable to the defense. And that's black letter law. So what they're saying here is, there's such a thing as attorney work product and it's not discoverable, but this isn't that, because he was talking or emailing over a burner account with a witness and getting statements from that witness. And that's absolutely discoverable. There's no question about that. As noted above, D.A. Morrissey appended to his email a message sent by Jennifer McCabe to a yet unknown member of the prosecution team that reads, I know it's late, but I am horrified that Chris didn't get it, and she's horrified that Chris didn't get it, and I am even more disgusted that for the second time, someone from the court leaked it right away to Mr. Carney. Since this message was not included in the communications received by the defense in response to a Rule 17 motion directed to communications between Ms. McCabe and Trooper Michael Proctor, it was presumably received by another member of the prosecution team. So the motion goes on and on and on, setting aside whether these communications constitute statements under Mass Rule of Criminal Procedure 14, subject to mandatory discovery on request. Prosecutors also must disclose material and relevant statements of persons within their possession, custody, or control. Ms. Reed herein requests that any communications constituting statements of persons the Commonwealth intends to call as witnesses at the second trial in this manner be produced. So we can kind of boil this all down by saying, if Mr. Morrissey was going back and forth by burner emails and telephones with these witnesses in advance, that's kind of like conducting a deposition without the other side there and being shady about it.
Mm-hmm.
And so,
I'm trying to hide it seems, is the weird part.
yeah, I mean, we can do depositions where, the other side is there and the witness is there and everybody's there. The stenographer's there writing everything down. So it's all above board. Whether it goes well or not is another question, but it's all above board. You don't start calling witnesses in the middle of a case or emailing witnesses in the middle of the case and saying, well, what do you really think? What do you really think? What can we say? So, on a burner. So
give me the facts, give me the tea. I need all the juicy details.
So interesting detail that's coming up at this point in the case. One of the other motions that was filed in this flurry of ratcheting up Read 2.0 was the defendant's response to the Commonwealth's notice of scheduling reassembly and testing of the defendant's Lexus telematics system. Did I say that right?
I'll go with the sure.
Okay. During the trial, the telematics system of Ms. Reed's vehicle became an issue. And now that there's a new special prosecutor and they're ratcheting the case up, the Commonwealth has said that they've disclosed a new expert that's going to open up the chip in the telematics system and take another look because they're desperate to see if they can find more evidence that Karen Reed's Lexus backed up and hit someone. They didn't have it in the first trial, but anyhow, the defense is now saying, wait a minute, this new expert doesn't know what they're doing. But this is in legal terms, this is how the motion reads. Now comes the defendant, Karen Reed, or the defendant, and respectfully files defendant's response to the Commonwealth's notice of scheduling, reassembly, and testing of defendant's Lexus telematics system. As set forth herein, the Commonwealth's new digital forensics expert, Shannon R. Burgess, has opined that there were deficiencies in the chip-off procedure conducted by defense expert Maggie Gaffney on the defendant's Lexus infotainment and telematics system as a result of what he claims may have been programmer's error. As set forth herein, Ms. Reed objects to the Commonwealth's position with regard to the new testing protocol as follows. 1. Defendant vehemently disputes Mr. Burgess's characterization of the chip-off procedure conducted by Ms. Gaffney, which is based on Mr. Burgess's fundamental misunderstanding of the difference between a megabit, M with a little b, and a megabyte, M with a big B. And 2, Ms. Reed respectfully requests that the court adopt the protocol proposed by defense expert Matthew D. Segura for any future testing of the infotainment and telematics system, which properly accounts for Mr. Burgess's misunderstanding relating to the storage size of the chips in question, and seeks to prevent further mistakes by Mr. Burgess, which could result in the unnecessary destruction of evidence. So
it's like little kids and the toy breaks. It's
yeah.
like, Mom, he broke it.
Yeah. I guess some of the testing on these things would, destroy the evidence. And that you see that in a number of different areas in the law where an expert comes in and, in order to get the information, you have to destroy the information.
Mm-hmm.
So.
And also with just like the megabit and the megabyte, there are different metrics of data, and based on those metrics, you'll be doing, different things related, like one can only handle so much.
Well, let's go down into the weeds a little bit. Because you're going to help us figure this out. Highly qualified defense expert Matthew D. Segura, and I know I'm not saying that right, and I apologize, Mr. D. He is a licensed professional engineer and certified IPC specialist with Delta V Forensic Engineering, Inc. He's reviewed the chip-off work conducted by Ms. Gaffney and opines that Mr. Burgess misunderstands certain basic digital forensics concepts, including inter alia, the conversion of megabytes, M big B, to megabits, MBS. Is that right? MBS? Okay. Negating certain of his opinions and necessitating that certain extra protocols be put into place to prevent programming error by Mr. Burgess. And this is all in an exhibit that is attached to this document. As set forth below, Mr. Burgess's incorrect belief that the initial chip-off procedure failed to retrieve all of the data because of programming error stems from his misunderstanding regarding the storage size of the chips in question. Notwithstanding that fact, Ms. Reed consents to a chip-off procedure. I should say a chip-off procedure. Is there a difference between a chip-on and a chip-off?
The chip on it, I need just, those two methods I'm not quite familiar with, but in the context that they're being used, they seem to be different things.
Okay, is it that, and we can delete this part, it's okay. Is it that a chip-on procedure leaves the chip in the device and the chip-off procedure takes the chip off and puts it in some kind of a testing panel?
I feel like that could be a good analysis. Off the top of my head, I'm not sure. I did try to do a little quick Google search before, and I didn't come up with a conclusive answer. But it looks like they're just that they are willing to work in this regard to help them figure out how much data the actual chip has. So I agree with the chip. Maybe that the chip off could be what's potentially damaging. The chip on is what's safer, and to help prove that they already got all the data.
Oh, okay. I think that's correct from the context of this motion. Mr. Burgess fundamentally misunderstands the difference between a megabit and a megabyte. And I didn't before today. I'll be honest. I was not a great math student. I'm sorry, Dad, the engineer. But if you're an engineer and you're testifying before a jury as an expert, you better know the difference between a megabit and a megabyte, okay?
And Andrew is, because I had this conversation, or I had this similar thought process where I'm like, oh, well, you can have like a megabit and a megabyte, and it makes sense that somebody would mix that up. But at the same time, like in computers, in this situation, there's like black and white answers. Computers work off of ones and zeros. So you messed it up, you have completely ruined the context of this. This is not to go back to however many gigabytes, the terabytes in a different court case. But when you have a different understanding of the size of this data, it makes a significant difference if you think that it's going to be something bigger than it actually is.
Yeah, and I think the analogy kind of would be if I'm just having a conversation with somebody in my office and somebody asks me, what is adverse possession? I'll say, well, it's possession of property that is open, continuous, exclusive, adverse, and notorious. And so, but if I'm going to try a case on that subject, which I have for a week and a half, I'm going to spend hours and hours and hours and hours preparing and researching and bringing up my cases so that when I'm testifying to a judge, or I should say, when I am speaking to a witness and eliciting testimony, I know what it is. So it's a difference between just not knowing and knowing. And if you're a witness in a case in front of a jury, as was this expert, or as this expert proposed to be, you should know what you're talking about. So here's the rub. Here's the importance of this whole motion. As explained in the attached declarations of defense expert Matthew D. Segura, and excuse me again, Mr. D, Mr. Burgess misunderstands the difference between megabytes and megabits, M capital B's and M little b's. In point of fact, manufacturing specifications establish that the total flash memory component of the chips in question is equal to 64 megabits, not 64 megabytes. Significantly, 64 megabits is equal to 8 megabytes. Thus, Ms. Gaffney successfully acquired 8 megabytes of data from the chips during the December 2023 chip-off, which constitutes the total flash memory component of the chips in question. Converting megabytes to megabits is a basic digital forensic concept, which is critical to successful data acquisition and analysis. Mr. Burgess's failure to properly record the total memory capacity of the components at issue could cause the Commonwealth to seek and perform unnecessary destructive testing, which could in turn result in the unnecessary destruction of evidence. I think, having read that a couple of times now, I think I understand what they're saying is that if the chip has so much memory capacity to it, and you download the information off of that chip, that's that. The Commonwealth's new expert erroneously miscalculated the amount of information that was on that chip, thinking there would have been a lot more, but he used the wrong ruler, he used the wrong scale, he used the wrong measure of the amount. And so it's unnecessary for him to go back when that's all there was. I don't know. Am I right? You're the expert here.
I think that's a fair kind of comparison to it. And it does get a little bit confusing going back between the bytes and the bits. But generally, I think you're right, where it's if you use the wrong ruler, you're going to get a different measurement, where it's like you were trying to measure feet and instead you measured inches along those lines.
So accordingly, as set forth below, the defense respectfully requests that a defense expert be permitted to be present during any future testing conducted by the Commonwealth, and that the defense expert be permitted to halt any testing and seek court intervention if Mr. Burgess makes any future mistakes which risk compromising the data at issue. This is so important because, I mean, we talked about this before we started recording this episode, and I've read this a few times. You're explaining it to me. I'm trying to understand it. But if we don't understand it on first blush, A, is the jury going to understand it? And B, what if they're given garbage information? The old saying, garbage in, garbage out. And I'm not talking about politics. I'm talking about if the expert is BSing them, MBS, if the expert is either intentionally BSing them or, can you say that on YouTube?
Probably.
Okay. We'll find out.
We'll find out.
Either the expert is intentionally BSing them or is incompetent. And it's hard to believe either way. I don't know. So the final point here is the conclusion. For the foregoing reasons, counsel respectfully requests that this court adopt the proposed protocol prepared by defense expert Matthew D., which is outlined in the affidavit of defense computer forensics expert Matthew D. and is filed herewith. And it supports everything in the motion. You would expect it to. We're not going to go that deep into the engineering aspect of it. And again, for those who have said, well, Alan Jackson's not in it, there's his signature, folks. In fact, looks like it came out of his office because it has, what purports to be a signature out of that office, Alan Jackson, Elizabeth Little at their office in Los Angeles, and then David Yannetti electronically signed it. Deep in the Massachusetts rules, there is now in a new Superior Court rule for electronic filings that anytime we sign a document with this little squiggly S, that is our signature. And we, Mr. Yannetti and any attorney who signs a document with that little squiggly X is swearing to the court that they are filing this in good faith, that they have read it, and everything in the document is true. So those are the motions that have been filed. The case is heating up. If in case you thought that things would just go along and trial 2 would be the same as trial 1. Remember after the first trial ended up in a mistrial and they set the initial date of January 27th for the trial. And we said, oh, well, why did they have to retry it all over again? It's going to be different. It's going to be very different. So the other things that have happened since our last episode is that both attorneys, both the prosecution and the defense, agreed on one thing. They filed a motion to continue the trial from the initial date of January 27th. They want it on April 1st. Which I thought was interesting. As we record this episode, the judge has yet to rule on that. The other significant thing that's happened is that a lot of people have said, well, they've said what they've said about Judge Canonian as a member of the Massachusetts bar. I don't do the name calling thing, and the trial was a train wreck. She will be on it for, unless something changes, she will be on it for case number 2.0 because the administrative justice has issued a ruling that Judge Canoni has now been assigned to be the judge in this case, and they took another case off her desk. They took the Brian Walsh case off Judge Canoni's desk and reassigned it. So the powers that be in the Massachusetts court system had said, yes, that Judge Canoni will be the judge on trial 2.0. And the final thing that we didn't do too much on is that the Massachusetts Supreme Judicial Court heard arguments on both sides. The reason I didn't do a whole lot on it is because the positions that were taken by the attorneys were pretty much the positions we've read over several times, in their initial motion to Judge Canoni to overturn the mistrial and to grant that counts 1 and 3 should be entered as not guilty, and that to try it again would be double jeopardy. We went over it at the Superior Court level. We went over it when the initial petition was filed with the SJC. We went over it again when the actual memorandums and reply briefs were filed. So on this channel, we've gone over those arguments about 3 or 4 times. So I didn't really feel the need to go over it again in another episode. I will say that the justices were critical of both sides and peppered both sides with questions. I did watch it. I did watch the hearing. And kudos to the podcasters who have the time to do it and to make comments. That's great. But so now the questions before the Massachusetts Supreme Judicial Court are whether not guilty should be accepted for counts 1 and 3, notably count 1 being second-degree M and count 3 being leaving the scene of the accident. And I hate to read between the lines of what a judge is going to do, but I find that doubtful. But the second question, which I find, I don't know if they'll go for it, but the Karen Reed attorneys want the jury polled. So those questions are before the Supreme Judicial Court. I don't know. Of course, we will cover that when those determinations are made. So do you have any final thoughts, Lainey?
Just poll them. Oh my gosh. I say it. I feel every time that we're on here. Just poll them. Just get this over with. Just get the answer. Why are we fighting about this? Why are we wasting time and money on this? How many filings have been placed when it could have just been one email sent to however many people? Anyway, I digress.
That question is now before the SJC. This case, it's a good thing that we're all mostly electronic now, because this case has generated so many pleadings and filings and affidavits and positions and experts reports. And I remember in the old days, you would see lawyers walking into the courthouse, carrying those 2-wheel trucks with banker's boxes full of papers. And this would be that case. But pretty much all of it's electronic now. And when you saw them trying the Reed case, there was a guy sitting in the corner in front of the bar, and he was the electronics guy. He was the guy that was providing all the data and the equipment, or I should say, he was providing all the data, the documents, if they needed a photograph, he was sitting there punching his computer. So that's how cases are tried now. And it's a good thing, because we don't want to tear down all the forests.
Yeah, and thank goodness, because they have been going back and forth with these things. So imagine having even just to print out just one of these documents, and it's like even the ink. It's just like all the resources all the time. This could have been a phone call, and it's not like this is coming out of nowhere. It's not the first time that this is being done. They had citations of other cases. So
if Lainey Law was a judge, she would have just called them all on court call
Oh, man, for
or
real.
Zoom or something. She would have just called them all. She would have called them way back in July when this whole issue came up. The day after the 4th of July, she would have called them all and said, hey, guys, what do you think?
They would have been on that bus, and I would have been like, all right, do I need you guys to come back here? It's just like I give so much credit to the judges. It's hard to work with people. It's hard to navigate these things. But oh my gosh, just get done with it.
Okay, stay tuned. We will cover it all as it unfolds. Have a good one.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.